Today we are going to discuss about the case Yogesh, Upadhyay and other versus Atlanta Limited. So in this case, Supreme Court observed that it has in power under Section 406 CRPC to transfer the check case from one state to another. Section 406 CRPC provides that power of Supreme Court to transfer the cases and appeal. So here we need not go through the facts again. So I'm directly going to observe the observations of the court. So the apex court noted here that it is now well settled that the offences under Section 138 of NI Act 1881 is complete upon dishonor of check. However, the prosecution in relation to such offence is postponed by the virtue of provisos thereon till the failure of drawer of check to make the payment within 15 days of receiving the demand notice. However, the jurisdiction to try this offence remains a troublesome issue for a long time. Here, the court recalled the case of Dashrath Rathod versus State of Maharashtra and another, which was held in 2014. 9 SCC 129 is a citation. Here, in this case, the three-judge bench of this court observed that the return of the check by the drawee bank would alone constitute the commission of offence under Section 138 of the Act, NI Act. It would indicate the place where the offence is committed. And it was therefore held that the place or venue of judicial inquiry and trial of the offence, it must logically be restricted to where the drawee bank is located. That is, where the check is dishonored upon the presentation and not where the compliance bank is situated. So in this case, court mainly observed that where the check is dishonored upon the presentation and not where the compliance bank is situated. Perusal of the statement of object and reasons make it amply clear that insertion of section 142 clause 2 clause 1 and 142A of validation of transfer of pending cases of NI Act by the way of amendment of NI Act was in direct consequence of this judgment in the court of Dashrath Rup Singh Rathod case. Section 142 clause 2 of NI Act. It now makes it clear that jurisdiction to try such an offence it would vest only in the court within whose direction the branch of bank where the check was delivered for collection to the account of payee or holder in due course is situated. The newly inserted section 142A of NI Act, it further clarified this position by validating the transfer of pending cases to the courts conferred with such jurisdiction after the amendment. Another case referred here is Bridgestone India Private Limited versus Interpal Singh in 2016 to SCC 75 has affirmed that the said legal position and endorsed that Section 142, Clause 2 and Clause A of NI Act 1881, it vests the jurisdiction for indicating proceedings for an offence under Section 138 in the court where the check is delivered for collection, that is, through an account in the branch of bank where the payee or holder in due course maintains an account. Therefore, the institution of the first two complaint cases before the court at Nagpur is in keeping with the legal position above. Court further observed that the power of this court to transfer the pending criminal proceedings under Section 406 CRPC it does not stand abrogated thereby in respect of the offences Section 138 of NI Act. Also, Honorable Supreme Court further noted that it had exercised the power under Section 406 CRPC in relation to the offences under Section 138 of NI Act 1881, even during the time of original Section 142 held the field. So, on the basis of these cases, Supreme Court observed that the six complaint cases pertain to the same transaction and it would be advisable to have a common adjudication to obviate the possibility of contradictory findings being rendered in connection with the different courts. So we know that the main purpose of Section 142 of NI Act 1881, it has been introduced to facilitate the transfer of pending cases to a single court in check bouncing cases to allow the complainant to have cases filed in different jurisdictions to be tried and decided by one court. So this would be necessarily mean that the complainant is saved the bother of approaching different courts when checks may be for same transaction. So this is not only the cut down the time, time and cost, but also it helped the complainant in recovery of his dues spread over the separate courts to one court. So, which in this case, it would the court that first approaches for recovery of amount due under the bounds to check irrespective of territorial jurisdiction of that court. And the very purpose is probably to cut down the time for deciding such commercial disputes that have arisen due to the dishonored check.
I'm discussing about the case Yogesh Upadhyay and another versus Atlanta Limited. This is a case filed in the Supreme Court of India under the criminal original jurisdiction, and the judgment was delivered by the single judge bench, that is by Justice Sanjay Kumar. The brief facts of this case is that the petitioner who filed for the transfer petition has brought certain missionaries for his business from the respondents under an agreement to pay the amount by seven installments by the way of check. He paid the first installment of nearly rupees 11 lakh, and that check was honored by the respondent. And later he gave six other checks also, and which got dishonored by the drawee bank, and this led to the filing of cases. Considering the six dishonored checks, was the first two checks were drawn from a Nagpur bank, and so the first two complaints were filed in the Nagpur court, and other four checks were drawn from Delhi. So the rest of the four other cases were filed in the Delhi court. So these cases which arise from the single transaction has been filed in two different courts. So the petitioner has appealed before the Supreme Court that a transfer petition should be allowed under Section 406 of CRPC, which deals with the power of Supreme Court to transfer cases and appeals for meeting the ends of justice. To transfer the two other cases in the Nagpur court to the Delhi court, that is Dwarka court in Delhi. And the main issue regarding this case that came before the court is that whether the Supreme Court has the power under Section 406 CRPC to transfer cases that deals with the check bouncing cases under Section 138 of Negotiable Instruments Act. In this case, the counsel for the petitioner argued that all the checks, all the as the checks are all related to the same transaction, it should be proper that all these cases has to be tried and decided together. While the defendant counsel for the case has argued that Section 142 of the Negotiable Instruments Act override the Section 406 CRPC, and in that connection, the court doesn't have the power to transfer the case from Nagpur court. Now, when the court took all these considerations into matter, it was it is stated that an offense under Section 138 Negotiable Instruments Act, which actually deals with the dishonor of check and related crimes, have been already been decided by previous set of precedents, where the prosecution of such an offense starts only if the drawer of the check failed to make the payment within 15 days of receiving of the notice for returning of the money. But when this comes to the jurisdiction, regarding the jurisdiction of the courts, where the case has to be filed, there is some kinds of ambiguity. Here, the court has considered a few cases to deal with this case. And the first one is K. Bhaskaran versus Shankaran Vaidyan Balan and another, that is a 1999 judgment. Here, the court held that while considering an offense under Section 138 of Negotiable Instruments Act, there are mainly five components. That first one is drawing of the check. Then there is presentation of that check to the bank. Then the refusal of the bank for the payment by dishonoring it, and the giving notice to the payee to give back the money, and the failure of the payee to pay the amount within 15 days. All these five components should be there to constitute a Section 138 of Negotiable Instrument Act offense. And in this case, also the court held that the courts having jurisdiction of the territorial limits, wherein the five components of this act have occurred, the jurisdiction and that court have only the jurisdiction to deal with this case. But later on, when it came to the another case, that is Dashrath Roop Singh Rathod versus State of Maharashtra and another in 2014, the three-judge bench of the Supreme Court held that the return of the check by the drawee bank would alone constitute the commission of an offence under Section 138 of Negotiable Instruments Act, and the case can be filed. That is, the place for the inquiry and trial of the offence should be restricted to the place where the drawee bank is located, and not where the complainant's bank is situated. And here, Section 140 of the 142 of the Negotiable Instruments Act was also considered, which deals with the cognizance of offence. Here, the Section 142 of the Negotiable Instrument Act states that, notwithstanding anything in CRPC, no court shall take cognizance of the offence punishable under Section 138 of Negotiable Instruments Act, except except when a written complaint by the payee or the holder of the check and the complaint is made within 1 month from the date on which the cause of action arises. So in the same section itself, it states that no court inferior to the metropolitan magistrate of the or the judicial first class magistrate should try the offence under section 138. This was what is stated in section 142. Later, coming to the Negotiable Instrument Act, it was amended in 2015. The section 142 clause 2 and 142 clause A was added. And in section 142 clause 2, it states that the offence under section 138 shall be inquired and tried only by a court within the local jurisdiction if the check is delivered for collection through an account where the holder or the payee has maintains the account. So this was pointed out that section 142 is maintained in this case that the court of Nagpur has exclusive jurisdiction to try the first two cases. Now, when this amendment, when the question arises, the amendment of section 142 was also considered here, and the court says that the new amendment made in section 142 was incontestable with the ratio laid in Roop Singh case, that the territorial jurisdiction has been already fixed there. Similarly, another case was also cited in the judgment, that is Bridgestone India Private Limited versus Inderpal. That is a 2016 Supreme Court decision. Here, the court stated section 142 clause 2A of the Negotiable Instrument Acts states that the court where the check is delivered for where the court is delivered for collection, that is through an account on the bank the branch where the pay or hold maintains an account, that is where the bank is situated, that court has the jurisdiction. And considering all these provisions, the court held that even though the first two cases have been filed in the Nagpur court, and Nagpur court has the jurisdiction to try the case, but when it comes to the section 142 and 406 of CRPC, the section 142 does not restrain the Supreme Court's power under section 406 to transfer the cases to another court for meeting the ends of justice. Here, both the first two cases has been filed in Nagpur and other four cases has been filed in the Delhi court. So transferring of these two cases from Nagpur court to the Delhi court cannot be restrained to meet the ends of justice. So the court has transferred the two cases back to Delhi High Court to be tried together.
In the case of Yogesh Upadhyay versus Atlanta Limited, 6 checks, which are the subject matter of the complaint cases, were issued by the petitioners in connection with the purchase of a crusher plant from the responding company under an agreement. This sale consideration was to be paid in 7 installments by the way of checks. The first check was issued by the petitioners and was duly honored. The remaining 6 checks, however, were dishonored. Here, a total of 4 out of 6 cases were filed by the petitioners before the Dwarka courts at New Delhi, while 2 such cases are still pending before the courts at Nagpur, Maharashtra. The petitioner accused had approached the Supreme Court to seek the transfer of the 2 cases from the Nagpur court to the Dwarka courts. Now, the issue here is whether check cases can be transferred from one state to another, invoking Section 406 of CRPC. Here, the Land Council appearing for the petitioners argued that all the checks related to the same transaction, therefore it will be proper that the cases pertaining to their dishonor are tried and decided together. But the Land Council for the respondent argued that Section 142 of the Negotiable Instruments Act 1881, which is the cognizance of offences, would override Section 406 of CRPC, which gives power to the Supreme Court to transfer the cases and/or appeals from one High Court to another High Court. Therefore, in the view of the non-obstantive clause therein, the two cases filed at Nagpur, Maharashtra cannot be transferred. The court referred to certain cases like K. Bhaskaran versus Shankaran Vaidyan Balan and also Dashrath Rat Singh Rathod versus State of Maharashtra. Certain amendments were made in the Act under the Negotiable Instrument Amendment Act 2015, and Section 142, Clause 2 was inserted along with Section 142A. A. Premanand versus Escorts Finance Limited is a case which assisted the court to make a decision. The court noted that the offences under Section 138 of the Act of 1881 had arisen out of one single transaction and found it appropriate and in the interest of justice that all such cases should be tried in one court. Therefore, in the case in hand, as the six complaint cases pertain to the same transaction, it is advisable to have a common adjudication to erase the possibility of contradictory findings, which may be rendered by different courts. 4 of the 6 cases have been filed by the responding company before the Dwarka courts at New Delhi, and only 2 such cases are pending before the courts at Nagpur. So the court finds it convenient and in the interest of all concerned, including the parties and the witnesses, that the cases be transferred to the Dwarka courts at New Delhi. Therefore, in this case, under the division bench of Justice Dinesh Maheshwari and Justice Sanjay Kumar, it was noted that despite of the non-obstantive clause under Section 142 Clause 1 of the Negotiable Instrument Act, the power of the court to transfer criminal cases under Section 406 of CRPC remains intact for the offences under Section 138 of the Negotiable Instrument Act to meet the ends of justice. And in my opinion too, I feel that the court has taken the right decision of transferring the 2 cases to a single court along with the other 4 cases, as it would definitely be convenient for all those who are involved in this case. And also, Section 406 of CRPC itself points out that the Supreme Court has the power to transfer case for the ends of justice.